to introduce one of our favorites, Mark Levick, on the topic of we don't think you should publish that information, says the U.S. government. Mark has been with us for the last few years. He teaches several classes at Pierce College Encore program, and I encourage anybody to look into those programs. They're really very interesting. That's where I first met Mark, and have been happy to welcome him back. He was born in Clearwater, Florida, grew up in northern Indiana, and graduated from Indiana University with a BS from the School of Public Health, Public and Environmental Affairs, which is a very long name meaning government, and then from Indiana University School of Law. After practicing law in the areas of mergers and acquisitions and tax for more than 13 years, he moved to California, and in 2010, he began teaching American government at Pierce College in Woodland Hills and discovered that teaching was more enjoyable than he had imagined. In the following year, he began teaching a current events class at the Pierce College Encore program for older adults. In addition to American government classes, current events classes, and so we're really happy to welcome him back today. Each summer he teaches a non-credit seminar, including recent interesting decisions of the U.S. Supreme Court, and sometimes just days or weeks or minutes from when the Supreme Court has issued some of its rulings. So Mark, welcome back. We look forward to what you got to tell us and teach us today.
Thanks for having me today. I'm checking my cell phone to make sure I've turned everything off, although that emergency warning thing, in case there's an earthquake may go off. I apologize in advance. Well, thanks for having me today. As Joel mentioned, I teach at Pierce College, and one of the fun classes, I mean really fun, is a class in the summer that runs 8 weeks, begins in mid-June and runs through the 1st of August or so, in which I discuss the recent interesting Supreme Court cases, which are usually pretty controversial, cases that many of my students have very strong opinions about, sometimes on both sides of the result. I worry and get stressed every spring around this time because I look at what the Supreme Court is doing and I think, will there be enough cases to discuss for 15 different 2-hour classes? Fortunately, the Supreme Court, and in this case, the chief executive, is probably going to come through for me because the chief executive is in front of the Supreme Court about as often as he wants to be. When the administration does something that's big, the Supreme Court is asked to intervene, and they almost always do. Doesn't mean they'll rule for him, but they'll almost always intervene on his behalf and at least hear the case and render a ruling. Today I want to talk a little bit about a case from last term, and that's a case involving the First Amendment and government censorship, or government persuasion, depending on your point of view. The case involved the 2020 election and the 2020 pandemic that kicked off in February or so of 2020. And social media companies like YouTube and Facebook and Instagram and TikTok and Snapchat and all of those wrestled with what to do when people posted things on their social media companies' websites that were not accurate or represented out of the mainstream medical advice. I've got some retired physicians in my Encore classes, and they did yeoman's work throughout the pandemic, helping everyone understand, no, ivermectin and hydroxychloroquine are magic bullets, just like beans that you plant and hope to grow, all the way up to the clouds. Whereas the actual vaccine and Paxlovid and remdesivir, those are real, and those are things that we care about. And mask mandates and stay-at-home orders had their place, and they were meant to make sure the emergency rooms weren't overflowing, which they were in Los Angeles in the winter of 21-22 and in the winter of 22-23. And one of those winters, more people died in LA County every day from COVID-19 than all other causes combined. Not just the number one cause of death, but the number one cause of death that exceeded all the other causes of death combined. Ultimately, we lost about 1.3 million people in a fairly short amount of time, and it caused a big spike in total numbers of deaths. That spike has come down now because COVID-19 isn't claiming as many victims as it was. But because the Biden administration, once it was elected in the fall of 2020 and took over in January 2021, they decided that they wanted to help Facebook and Instagram and YouTube and all of those platforms with the actual truth. And so Vivek Murthy, he was the Surgeon General, and others involved in the Biden administration talked to people at those social media companies and gave them persuasion or cajoling or tried to get them to de-emphasize things that were medically nonsense and to emphasize the actual facts, even when those facts had a very large following of people who didn't believe them. So I want to mention a couple of the things that the Biden administration people did to give you an idea of what we're talking about here. Eventually, the states of Missouri and Louisiana filed a lawsuit and said, this is awful because you are emphasizing facts that we don't agree with, and you're talking to these social media companies and getting them to de-emphasize things we do agree with. And that sounds like government censorship. Imagine this example. If Donald Trump had a hotline to the doctor that owns the LA Times, and the president looks at the LA Times and says, I don't like this story or this story or this story, and the president got an advance copy, say, and the president called the publisher and said, why don't you kill this story? I don't like that. Many of you would say, well, you can't do that. That would be government censorship. And the First Amendment, right, says Congress shall make no law respecting an establishment of religion or interfering with the free exercise thereof, or limiting the freedom of speech or of the press or of peaceable assembly. All of those restrictions on what government is allowed to do. And so when government like the Joe Biden administration contacts these social media companies, I was disappointed. Not because it's a partisan issue, not because of a Joe Biden versus Donald Trump issue. I'm disappointed when government doesn't trust 340 million Americans to moderate their own speech or have companies willing to moderate the speech for them. As you probably know, all of the social media companies employ people who are there to decide, ooh, that racist speech we're not going to allow, or that anti-Semitic speech crosses a line, or that non-scientific vaccines cause autism nonsense. We're not going to allow that to be on the platform. And it's worked out pretty well. Now, there's one exception. Once Elon Musk purchased Twitter, he let go of 80% of the staff. And many of the people let go were involved in deciding who was worthy of being on the platform and who was not. Note that as soon as he took over in the fall of 22, he welcomed back everybody that Twitter had spent years figuring out their identities and either banning them or suspending them or putting big warnings on everything they posted. You know, people like Kanye West, who has had some tremendous meltdowns recently. He's selling shirts with swastikas on them, saying he loves Hitler and that he's a Nazi, for instance. He did that the evening before the Super Bowl so he'd get lots of attention. In the old days of Twitter, he would have been banned, and I think he was. Well, the lawsuit that was filed by some doctors out of the mainstream doctors, not normal doctors, but out of the mainstream doctors, and some users of Facebook and the attorneys general of Louisiana and Missouri, they filed a lawsuit that said these government officials, not Facebook, they didn't even sue Facebook or the social media companies, they sued the government officials and said government officials have no business leaning on, persuading, cajoling, talking to, trying to influence what is posted by, Americans. And the district court, the trial court said, you're right, and issued a preliminary injunction. And then the Fifth Circuit Court of Appeals, that's located in Louisiana, but it covers Texas and Louisiana and one other state. They agreed and said what the Biden administration was doing was wrong because it amounted to censorship of ordinary Americans' free speech. And remember, when government says you can't say something, well, that's what the First Amendment is all about. Eventually, the case made it all the way to the Supreme Court. And I'll give you just a little flavor of some of the things they did. Justice Barrett wrote the majority opinion. And in this one, if you don't think Justice Barrett is fair-minded, I'll point you to this decision and say she's very fair-minded. This was one of my favorite decisions of the past year. During the 2020 election season and the COVID-19 pandemic, social media platforms frequently removed, demoted, which made it harder for the content to be found, or fact-checked by putting a fact-checked label on somebody's posts. Posts containing allegedly false or misleading information. At the same time, federal officials concerned about the spread of misinformation on social media communicated extensively with the platforms about their content moderation efforts. The plaintiffs, 2 states and 5 social media users, sued dozens of executive branch employees and agencies, alleging that they pressured the platforms to suppress protected First Amendment protected speech in violation of the First Amendment. The Fifth Circuit agreed with them, concluding that the officials' communications rendered them responsible for the private platform's moderation decisions. Essentially, the FBI and the CDC and all of these government agencies and officials were acting as if they were the moderators of private companies and not the private companies. A little bit of a digression here. You do know that if you send a letter to the LA Times and they decide not to print it, you have no recourse, right? They don't have to print anything they don't want to print. And you do know that if you publish something on an online platform, say a bulletin board, an online bulletin board that's dedicated to your favorite hobby, and you get into a little verbal tussle with somebody else on the platform and you start saying things that are mean, the owner of the website can say, well, you're the problem. You are suspended for a week or forever, and there's nothing you can do about it. You have to follow the rules of wherever you are. The same thing is true when you're in a place like this. I need to hew to the accepted decorum and other rules, or else I might find myself unwelcome with no recourse at all. It's unlikely, but it's always possible, right? The Fifth Circuit was wrong to do so, she says, Justice Barrett. To establish standing, the plaintiffs must first demonstrate a substantial risk that in the near future they'll suffer an injury that's traceable to a government defendant and redressable by the injunction they seek. Now, we're not going to go through all the standing because that's very technical. As you know, when you file a lawsuit, especially in federal court, you must show that you have standing. You can't file a lawsuit complaining that somebody's been mean to somebody else. Somebody has to have been mean to you, and then you'll perhaps have standing. The majority here concludes there's no standing, especially since they didn't sue the most responsible party, Facebook. They focus here on Facebook because that's one of the primary ones, but they didn't sue Facebook. They aren't in the caption. And they said, you can't file a lawsuit and hope to get some kind of future action out of somebody you didn't sue. That's not how courts work. But I want to point out some of the activities that went on, because I think that's the key point. For years, these platforms have targeted speech that they judge to be false and misleading. For instance, in 2016, that was long before the pandemic came around, Facebook began fact-checking and demoting posts containing misleading claims about elections. That was in the 2016 Clinton versus Trump election cycle. Since 2018, Facebook has removed health-related misinformation, including false claims about a measles outbreak in Samoa. Robert F. Kennedy Jr. played an integral part in the spread of measles in Samoa by posting some of his nonsense about the measles vaccine, incidentally. And he's now the Secretary of Health and Human Services. I heard he did go to a funeral this weekend for the second victim of measles in Texas. And he might be coming around to the, measles vaccines are a good idea, which is something I thought we settled 50 or 70 years ago. And the polio vaccine in Pakistan. I'm a Rotary Club member, and the Rotary, along with Bill Gates, has been trying to wipe out polio in the last remaining villages in Pakistan and Afghanistan where it still resides. I fear that, the big change we've seen, again, Robert F. Kennedy Jr. may set that back a ways. Likewise, in 2019, YouTube announced that it would demonetize channels that promote anti-vaccine messaging. In 2020, with the outbreak of COVID-19, the various platforms announced that they would enforce their policies against users who post false or misleading content about the pandemic. As early as January of 2020, a year before Joe Biden came on the scene, Facebook deleted posts it deemed false regarding cures, treatments, and the effect of physical distancing. So they were helping to promote the mainstream medical advice and not the, out of the mainstream outlying medical advice. And Facebook demoted posts containing what it described as conspiracy theories about the origin of the virus. And you probably have heard all of that. Did it originate in a lab or in a market in China? Well, it didn't really matter where it originated. What mattered was how do we make sure the ERs don't overflow and have great big crowds where they start, doing triage out in the hallway. Well, you live, you die, you live. That's what they were doing in Italy before we locked down here. They had so many people show up at the hospital, they had to pick who get treatment and who didn't get treatment. And that was the reason we needed to flatten the curve, remember? Been 5 years since all of this was very relevant. So, over the past few years, various federal officials regularly spoke with the platforms about COVID-19 and election-related misinformation. Officials at the White House, the Office of the Surgeon General, and the Centers for Disease Control and Prevention focused on COVID-19 content, while the Federal Bureau of Investigation, the FBI, and the Cybersecurity and Infrastructure Security Agency concentrated on election nonsense and misinformation. In early 2021, and continuing primarily throughout that year, the Director of Digital Strategy and members of the COVID-19 response team interacted with the platforms about their efforts to suppress vaccine misinformation. They expressed concern that Facebook in particular was one of the top drivers of vaccine hesitancy due to the spread of allegedly false or misleading claims on the platform. Thus, the officials peppered Facebook, and to a lesser extent Twitter and YouTube, with detailed questions about their policies, pushed them to suppress certain content, and sometimes recommended policy changes. Some of these communications were more aggressive than others. For example, the Director of Digital Strategy, frustrated that Facebook had not removed a particular post immediately, complained, "The last time we did this dance, it ended in an insurrection." Yeah, sort of an ominous warning to the officials at Facebook. Another official, unhappy with Facebook's supposed lack of transparency about its vaccine misinformation problems, wrote, "Internally, we have been considering our options on what to do about it." And at one point, I think Jen Psaki, the press secretary for President Biden, after she got done talking about, making sure that the various social media companies got on board, she then, in an unrelated mention said, "We might think about ramping up antitrust enforcement." That wasn't very subtle. As you know, I think Google is facing an antitrust verdict right now that may result in the search function of Google being broken apart from the rest of Alphabet Google. And antitrust is something they've all faced, especially in Europe, where the EU seems to have a much more old-fashioned idea about antitrust than our let business do what it wants ideas that we've been working under here. And I don't say that to demean either political party. I was also providing antitrust advice back in the 80s and 90s and early 2000s to companies where we were becoming a much more free-flowing, anything-goes, laissez-faire approach to antitrust law than the older days after they wrote the antitrust laws and were breaking up all the big companies and denying merger after merger and that sort of thing. And then there's the CDC. Like the White House, the CDC frequently communicated with the various platforms about COVID-19 misinformation. In early 2020, again when President Trump was in charge, Facebook reached out to the CDC seeking authoritative information about the virus that it could post itself on Facebook. So Facebook was asking the CDC in early 2020, hey, help us out here. You guys are experts, you're the CDC, help us moderate so we don't inadvertently participate in spreading nonsense that would cause, an Italy situation, as I mentioned a moment ago. The following year, once President Biden was in office, the CDC's communications expanded to other platforms, including Twitter and YouTube and others. The CDC hosted meetings and sent reports to the platforms, alerting them to misinformation trends and flagging example posts that it found troublesome. The platforms often asked the agency for fact checks on specific claims. Now, it's notable here, none of the platforms relied on the federal government's officials exclusively. They also consulted with other experts, probably doctors like the retired physicians I mentioned are in our Encore program that did yeoman's work at cutting through some of the more egregious nonsense and explaining why the mask mandate made sense and why social distancing made sense at least for a while. And then we have doctors who actually read the vaccine studies and said these are safe and effective. Get your vaccine, and I've told people in my classes, we can't really be friends if you don't believe that the Moderna and Pfizer vaccine are safe and effective. One new student the other day said her doctor, she had COVID-19 early on, survived and didn't have terrible symptoms. And then she said, her doctor said no real need to get the COVID-19 vaccine. And one of the doctors in class said, well, number one, I think you need to get a new doctor. I was thinking that, but I would never say that. But one of our retired doctors said, well, number one, you need a new doctor. You need to change because that's not good advice. So against all of this conduct, I was disappointed. But was I correct to be disappointed? I don't want government telling newspapers, TV stations, radio stations, or social media platforms, which is where all the kids are, what they can print and what they can't print, what they can say and what they can't say. I want the social media companies and the LA Times and the New York Times and the Wall Street Journal, and I want CBS and NBC and ABC and all of them to make independent decisions. I believe in the marketplace. I'm a free market person and a free speech person. So I don't want government leaning on anybody saying, we think it best if you not say this. And from that, I got my title that you may have seen in today's program. I don't ever want the government to tell private actors, you shouldn't say this. Now that's distinct from government saying, well, this is a crime. You can't say this because it's a crime. You can think of an easy one, right? Don't threaten anybody. If you threaten somebody and make them fearful, that's a crime in every state I know of. And if you threaten a federal official or an elected official, that's a really serious offense. And your First Amendment won't protect you. I was just exercising my right of free speech. No, you're not allowed to make people fear for their lives or safety. And then it gets into a much more murky mess, some of which we're seeing right now. We're seeing people who said all kinds of horrible, hateful, awful things, especially last spring, about a year ago, on an awful lot of university campuses that so many people say, well, I don't agree with anything they said, but I'll fight to the death for their right to say it. And then there are other people who say, I disagree completely with everything they said, and they should have never been allowed to say it. And that's a taste great, less filling argument. Some of that may eventually get to the Supreme Court. We'll see, because the president is trying to get universities to get in line and either punish or deplatform or remove some of those actors from the past year. You know, those campus people that were either pro-Palestinian if you're on one side or pro-Hamas if you're on the other. Abhorrent conduct that even First Amendment lawyers, I think Dean Chemerinsky and others have said, well, don't agree with anything they said, but we can't get rid of people like that. David French is another First Amendment expert you've probably listened to or read in the New York Times. And he said, due process matters, and although he doesn't agree with anything those people said, they certainly can't be punished by the government for having said it. Can you be punished by the private sector for saying unpopular things? Oh, most certainly. And Exhibit A today is Elon Musk. He hasn't faced any government sanction for all the crazy, wacky things he's said and done lately, but he's certainly seen what the market does when your biggest investment is a publicly held company that sells cars all over the world and people are not buying as many of your cars and people are selling your stock more days than they're buying. I think before class it was down around 50% of where it was in mid-December. Volatility is the word there, but he hasn't been punished by any government that I know of, but he certainly faced the wrath of the marketplace, you know, which is where I think that should occur. So eventually you get to the bottom of this opinion. Ms. Barrett concludes that, let me get to the last page here. Oh, it's lengthy. These lawyers talk more than I do. And I thought I was the most talkative person who loves to hear himself talk. But she gets to the bottom of this decision on page, oh my gosh, 29, and concludes, the plaintiffs, all of the complaining people, the doctors, the Facebook users, the states, the plaintiffs, without any concrete link between their injuries and the defendant's conduct, ask us to conduct a review of the years-long communications between dozens of federal officials across different agencies with different social media platforms about different topics. This court's standing doctrine prevents us from exercising such general legal oversight of the other branches of our government. We therefore reverse the judgment of the Fifth Circuit and remand the case for further proceedings consistent with this opinion. Now, hidden inside of her opinion in the 28, 29 pages was a statement that many of the facts relied upon by the Fifth Circuit were clearly erroneous. You don't ever want to be a judge and rely on clearly erroneous facts, according to a higher court. That has to be one of life's embarrassing moments. I can think of a few others, but that would be a real downer for somebody who's a lawyer and a judge, especially a federal judge, a federal court of appeals judge, to be told by the Supreme Court, you messed up. You relied on clearly erroneous facts. You determined findings of fact that were clearly erroneous, meaning there is no real evidence to support your conclusion. Ooh, yikes. That's going to sting, and it's going to be around for a long time. Now, of course, it wasn't a completely unanimous opinion because, as you can probably guess, Justices Alito and Thomas and Gorsuch disagreed. But it was a 6-3 opinion, which means Roberts and Kavanaugh and Justice Barrett were joining the three democratically selected judges, the more liberal three, who I believe are now all women because Justice Jackson replaced Justice Breyer. And so it was a 6-3 opinion, but in 33 plus pages, Justice Alito goes on and on and on about what an awful, terrible thing this is. And he even brought up Hunter Biden's laptop. I don't know how that was relevant, but the Hunter Biden laptop story made the cut in Alito's lengthy dissertation. He was very disappointed because this meant that the Biden administration was going to get off scot-free. And as I mentioned a minute ago, I was disappointed that the Biden administration would get off scot-free too. Not because I believe everything Justice Alito believes, but because I don't want government doing that. I want the free market to determine what's truth and what's not. And if the private sector reaches out to the government, as they were doing in 2020 and 2019, saying, hey, we'd like some advice, CDC. Help us, determine what we should allow and help us figure out which of these things we should get rid of. I'm all in favor of that. You won't find me disagreeing. But when you turn it on its head and Biden administration officials are, having regular meetings and sending, getting out their red Sharpie and circling posts they disagree with and sending that to Facebook and YouTube and Twitter, that crosses a line for me. That goes a little bit beyond what I want to see. All in all, though, it probably was the right decision because procedurally, the plaintiffs messed up. They messed up completely. They didn't sue Facebook or YouTube, and they didn't ask for compensation for their past injuries. They wanted an injunction that prevented this from ever happening again. And in Justice Barrett's opinion, she explains, well, that's not possible. You goofed. Sue your lawyers is essentially the result of this case. Because when you don't win anything and the Supreme Court by a 6-3 margin says, well, you messed up. You better sue your lawyers for malpractice. Again, that's going to leave a mark. What an embarrassing case. But all in all, on balance, I guess it's not the worst thing that happened. Dean Chemerinsky did weigh in and said, when does government speech violate the First Amendment? As a dean of a public university law school up in Berkeley now, he was at Irvine, now he's been with Berkeley for a few years. Do I violate my students' free speech rights when I encourage them to speak respectfully to one another, to demonstrate civility, and to refrain from hateful expression? There are countless instances in which government officials speak out. Does that chill freedom of expression among those who disagree with what the official says? In 2 recent Supreme Court cases this term, including one decided just the other day, this is last summer, the justices rightly reaffirmed that speech by government officials violates the First Amendment only if it includes an implicit threat of sanctions. And Justice Barrett didn't find any threat of sanctions because, remember, clearly erroneous findings of fact by the trial judge and by the Fifth Circuit in that case. He talks about the National Rifle Association case where in New York, the administration of the state of New York punished the National Rifle Association by not allowing them to sell affinity insurance. A lot of nonprofits sell affinity insurance. They take a cut, and all the members of the organization are happy because they're supporting the organization and they get insurance. And this was gun insurance, which is, pretty important to the NRA. And so he discusses that one, and then he talks about the Murphy versus Missouri case that I just discussed. The court considered a suit brought by 2 state governments and 5 social media users against the Biden administration and many federal agencies, claiming that the First Amendment was violated by the government's encouraging social media platforms to take down false speech. No platform was threatened with or relieved of prosecution, but the businesses were told that if they did not take down false speech, especially about the effects of the COVID-19 vaccines and the election, they might face more regulations in the future. That's threatening when I hear it. A conservative panel of the Court of Appeals for the Fifth Circuit found this was a violation of the First Amendment, but 6-3, the Supreme Court ordered the case dismissed for lack of standing. He concludes with, these decisions are especially important in the context of the internet and social media, where false speech is a huge problem. The government has few tools to deal with it. The court's rulings preserve the ability of officials to encourage social media platforms to take down false speech. He concludes, well, less false speech on the internet and social media will benefit all of us. And I can't disagree. He's a brilliant man. Noting about Elon Musk and the lack of moderation, on October 8 of 2023, on Sunday morning of October 8, Elon Musk, always wanting to be the smartest person in the room, having purchased Twitter so he could be the chief twit, says the following: for following the war in real time, war monitors and Scent Defender are good, said Elon Musk. He posted on the platform formerly called Twitter on Sunday morning to 150 million of his social media followers on Twitter. That post was viewed 13 million times in 3 hours, drawing thanks from the 2 accounts that he promoted, and before Musk deleted his post. In case you didn't know what those two accounts did, the War Monitor account has argued with others over Israel and religion, posting a year ago that, quote, the overwhelming majority of people in the media and banks are Zionists, close quote, and telling a correspondent in June to, quote, go worship a Jew, lil bro, close quote. And plenty of anti-Semitic content and other falsehoods, things that were demonstrably false, posted by that account. Information researchers said the new conflict was an early test of how the revamped Twitter conveys accurate data during a major crisis. Musk left up his replies to those accounts even when he took down his original post because he wanted to make sure people could still find him and, get the actual truth, according to Mr. Musk. He also continued to fault the mainstream media, telling users to trust Twitter instead of the mainstream media. Other accounts on Twitter drew engagement with photos or videos of unrelated attacks from years before, claiming that they were part of the October 7 massacre. That's an area where, well, again, all the people that made the tough decisions are gone. The 80% staff reduction included almost everybody that decided that speech is too hateful or too anti-Semitic or too inaccurate to allow on our platform. So we're stuck with whatever is posted there now. And then there's the other case I wanted to talk about today. TikTok. Now, I'm hoping that very few of you are familiar with TikTok from a user perspective, because it tends to be what your grandchildren are all excited about. It's a platform on your phone where you can take videos, 15 or 30 seconds or whatever, and it's typically teenage girls dancing to some stolen music, some pop song. The artists now get paid, but they get paid about 1,000th of what they get paid if somebody listened to that music on Spotify or Apple Music. TikTok pays very, very small amounts for the stolen music. Well, as you might remember, back in 2020, former President and now again President Trump said, this TikTok is gathering up data from Americans and it's using this proprietary algorithm, which is the same thing that Vegas uses to get you to keep playing the slot machine. These algorithms provide just enough rewards so that people spend hours scrolling on their phone, looking at social media content on TikTok. And that's the whole goal. More minutes means more ads viewed, more money for TikTok. So President Trump said, this is owned by ByteDance, which is a Chinese company that is beholden to the Communist Party and is required to turn over anything that Beijing wants turned over. I have no idea how extensive this data might be, but they try to explain it in a very lengthy opinion. And this one was unanimous. It gets to the Supreme Court eventually, but first Donald Trump says, I'm going to sign an executive order banning TikTok. And then he signs another executive order saying you can't do this and this and this. And that was in the closing days of his first administration, so the TikTok and all the people who are really addicted to TikTok said, no, you can't do that. And they filed lawsuits, and well, then President Trump wasn't President Trump anymore, it was President Biden. And they negotiated for a couple of years about, can you do this, can you do that? And the negotiations went nowhere. And then Senator Tom Cotton, who is not always one of those people I admire, but in this case I admire him, he said, this is a security risk, because when a kid posts a video or reads a video and makes a comment on TikTok, TikTok gains access to that kid, that user's entire list of contacts. And then it basically harvests all the data about everything having to do with your contact list, phone numbers, locations, all kinds of detail that your friends might not have consented to. You're the one using TikTok, but it's mining the data that's on your phone that has anything to do with anybody you've ever emailed or called or texted or whatever. And so Senator Tom Cotton gets a bunch of his Republican colleagues and a bunch of Democratic colleagues together, and they said, let's pass a law that says TikTok either has to divest in a qualified sale so that the Communist Chinese Party no longer controls all this data, doesn't have access to it, can't get to it, And if they don't do that, we will order it shut down. And back in April of last year, almost a year ago, the Congress overwhelmingly voted. There were only about 50-some no votes in the House, and there were only about 18 no votes in the Senate. And Congress passed a law that said by January 19, TikTok must be sold to somebody unrelated to the Chinese, or it must go dark and go out of business. Now, this past January, President Biden was getting ready to leave. He was packing up his stuff, and Vice President Harris wasn't going to be moving in, and President Trump was coming back. So you would think that since he wanted it shut down back in 2020, he'd be on board with this new law passed by Congress. But no, President Trump thinks that TikTok and the young kids helped him get elected. We'll never have any data one way or the other, but you know, he's got some grandkids and they know TikTok. And I recall that President Biden said, well, I've got grandkids. One of his granddaughters said, well, I know social media. And I thought, oh, the election was now in the hands of the 18-year-olds who know social media. We won't have any evidence whether TikTok actually helped President Trump, but he is a little bit more aware of his constituency, I think, than he used to be. So he came into office saying, I want to do a deal. So when this case was heading to the Supreme Court back in early January, he filed a motion with the Supreme Court saying, I want to intervene. And they said, who are you again? Oh, you're the new president? Well, you take office in January 20, and you're not president yet, so no, we don't need to hear from you. But he was telling everybody who would listen, I'm going to do a deal, because, you know, art of the deal, I make deals, and so I'm going to do a deal. The law didn't have any provision for not enforcing the law, but Joe Biden, on his way out, remember, it went into effect on Sunday the 19th. President Biden said, not my problem. He's basically packing up the classified documents in those boxes. No, he was getting ready to move out of the White House. And he said, I'll leave it to my successor, President Trump, to deal with. President Trump comes in on day one and he says, I'm going to grant a 75-day extension to TikTok so that they can work out a deal. And I think today he just announced another 75-day extension because those tariffs angered some of the people in China, from what I heard. And so any discussion of a deal fell apart, of course. And so now we're in phase 2, another 75-day delay. Well, the law doesn't have anything about a delay by the president, but you do know he's really the chief law enforcement officer, right? He appoints the Attorney General, Pam Bondi, and Pam Bondi has said, well, we're going to let the president work this out. And so you've got Republicans who, I don't want to say they've lost their voice, but they seem to be pretty quiet most of the days, although some of them are starting to complain about the tariffs because they're hearing it from home. But they're not all up in arms, even though they overwhelmingly voted for a ban on TikTok or a sale. Last I heard last week, it was maybe Amazon was going to purchase it. The thing is, ByteDance, the Chinese company, is not going to let go of their algorithm. That's the valuable part. Hundreds of millions of emails and a whole bunch of stupid videos that they have in their library isn't the valuable part. It's the algorithm. Because it's better than the Las Vegas algorithms. It's better than the one Facebook uses. It's the best, according to actual techie experts, because it holds the kids' attention. LA Unified now starts school at 8:30 because so many educators and scientists say young people need more sleep. It's because young people are scrolling on their screen at 11, at 12, at 1 in the morning because they just can't put TikTok down. They just have to look at it. I'm going to teach in the fall in an LA Unified school, and they just banned cell phones district-wide a few weeks ago. I'll see how that works out, because before it was, I just want to read TikTok and see the videos and look at what's happening, said so many of even my students. I'm pleased that very few of you are scrolling TikTok videos, but if you want to check up on the news, that's okay, I won't be offended. But kids just wanting to look at TikTok videos. The Supreme Court in this one said, you know, this is a difficult case because what we're doing here is potentially banning a social media company that 170 million Americans use. In 2023, they posted 5.5 billion, with a B, videos, just American kids. Then they were viewed 13 trillion, with a T, times around the world. 5.5 billion videos by Americans were viewed 13 trillion times. Even a tiny, tiny fraction of a penny for each one of those means somebody's getting a lot of money. The people who create videos that are widely seen do get paid by TikTok. The advertising revenue, some of it gets their way. Same thing on YouTube and Facebook, where prolific creators of content share in some of the riches, that the parent company gets. They get a fraction of it. But in this case, they concluded, and again, in a unanimous opinion, that it really doesn't impact the First Amendment that much. Now, at first I thought, wait a minute, of course it does. You're banning a social media platform, potentially. But think about it this way. What if Al Jazeera came up with an app, and that app provided some useful news to people, actual news, not what they do provide, but it provided actual news, and somehow they attracted all the young people in Israel who don't know better, young people, to get on that app and look. And then it turned out that the Al Jazeera app was harvesting every useful piece of data imaginable. Does anybody think the Knesset would waste a minute before they banned that? That app would be banned immediately. And in fact, Israel has tried to discourage and maybe ban certain, perhaps even parts of Al Jazeera in the physical sense, the TV cameras and the reporters' sense, because of a concern that national security outweighs the freedom of Al Jazeera to conduct their operations. But if it were an app where everybody at home had access to that and was sharing basically all the classified information that Israel doesn't want shared, it'd be banned in a minute. And that's what's happening here with TikTok. Now, the criticism I have is it's been around since 2017, and it's 2025. It's grown, but it was popular in 20, and it was popular in 19, it was popular in 18. We've already let that cat out of the bag, or the horse has left the barn at this point, hasn't it? If there was valuable information to harvest, Beijing's already got it. Nobody was making that argument, but it does bug me that here we are in 2025 saying, oh, by golly, we're going to make a stand and secure our national security information. And I agree, like I said, with Senator Tom Cotton. I think he actually has the nation's security at heart here. And so do all the other senators and all the other House members. Again, it was overwhelmingly approved. And then Joe Biden signed it when he was president. So I'm torn here because I don't want them to say, national security, says President Trump tomorrow, requires that we take down the social media or the websites that Levick likes. What if the New York Times and the Washington Post and the Wall Street Journal are suddenly subversive? And they convince a bunch of the people in Congress. I don't think it'd be as widely bipartisan, but they get a majority in the House and Senate to say, these platforms will all be shut down, and Levick can't look at the New York Times or Wall Street Journal or Washington Post at his leisure because somehow national security has been compromised. I don't want that to happen. I don't like precedent that allows someone later on to say, well, you did it with TikTok. The Supreme Court said we could do it. All we have to do is say the magic words, national security. As an aside, you may have noticed that in enacting his tariffs, the president has said the words national security and emergency a whole bunch, when I'm not sure we have a national security emergency with Canada or Mexico, a couple of our very close trading partners, but the president's authority is somewhat unbridled there. A couple of other things I want to mention in my remaining minutes are some of the cases that are coming up. And that's going to be the birthright citizenship case, which I think is already at the Supreme Court. The president came into office and said, birthright citizenship shouldn't exist unless you're here with permission, and then your kids are entitled to citizenship. The tough part is this. Does that mean whenever some young person who was born here to non-citizen parents, before they can get a copy of their birth certificate and get a passport, will they have to have an immigration proceeding? Because some bureaucrat down at the office where they issue birth certificates say, I don't know if this person's entitled to one. I need to make sure your parents were here with permission. You can see immediately that would become an administrative nightmare. The fact that you were born here it makes it a whole lot easier on everybody. It doesn't apply to people who are here as diplomats. We have diplomatic immunity with practically the whole world so that their diplomats are here. They can do all kinds of terrible, awful things, and we say, well, it's a shame you did that, but you're free to go. Remember back in the first Trump administration, there was an ambassador to Britain, and I think their spouse was driving on the wrong side of the road, thinking it was the right side of the road, and hit a person on a motorcycle, I think, and killed them. And the Brits said, well, that person ought to be willing to stand trial because, that's not something diplomatic immunity was there to cover. And the spouse jumped on the next plane back to New York and said, no, I'm not going to stand trial. And there was a brouhaha about it, but, the bottom line is, if we don't allow diplomats and their families immunity for almost everything they do, there'll be more of our people picked up on the streets of all the countries that don't follow the same procedural protections that our country follows. And so we'd have to, be springing a lot more people out of Russian prisons and jails and other places around the world where they would just grab our diplomats and say, they did something wrong. They're here, espionage, which is, I think, what Mr. Putin likes to say about everybody that he kidnaps and puts in jail. So the birthright citizenship case is definitely going to be decided by the Supreme Court soon. I predict before the end of the spring semester. There's a couple of others. I think the president has lost about 6 cases so far in the district courts, in the trial courts. He's had some victories in the courts of appeal, some of which have overturned those district courts. But that leaves a whole bunch that I'm certain the Supreme Court will get to. There was one more thing I wanted to mention, and it goes back to that TikTok case, and that's Dean Chemerinsky. Dean Chemerinsky, back before the Supreme Court ruled in the TikTok case, he said, the Court of Appeals got it wrong. He said this was a free speech case, and they should not have allowed this law to go into effect that would ban TikTok. And then after the Supreme Court ruled at the end of January, Dean Chemerinsky said the Supreme Court failed to address whether the Chinese access to TikTok data is a real national security threat. And I highlighted and underlined a whole bunch of things, and I read it about 5 times, and I said, I can't believe I disagree with Dean Chemerinsky. It's obviously a me thing, not a Dean Chemerinsky thing. It's obviously something wrong with me. But I read it and I just can't get past. He said that the Supreme Court was too willing to allow, in the TikTok case, Congress's assertion of national security concerns to rule the day. And I looked at it and I said, I'm disappointed because it's the first time I've ever read anything from Dean Chemerinsky that I disagreed. So again, it has to be me. It can't possibly be him. But every time I read it and try to figure out how I got it wrong, I'm drawing a blank. What is missing in the court's analysis, he says, is a discussion of what information China can obtain and how that information can be used to damage our national security. Well, the court, we don't know who wrote this opinion because it's called a per curiam opinion, but it was a unanimous opinion. 2 judges wrote concurring opinions, so we know they didn't write the majority opinion, but there were 7 others, and in there they said there was tons of evidence the House and the Senate considered. They cited to the committee reports of the House and Senate. They cited to the fact that it passed overwhelmingly and that there were debates about it that went on and on. This wasn't some budget bill passed in the dark of night, at midnight. Here's your 2,000-page spending bill. You've got a few minutes to peruse it, and then we'll vote on it. This was considered and debated. It's a really short bill. The law is very brief. They could read it in several minutes and then debate the merits of this TikTok ban. So I'm coming up blank. If anybody knows, help me out here. Why is it that he didn't want to believe Congress? Now, I don't always believe Congress, but I'm less inclined to believe the president. When the president says something, whether it's President Biden or President Trump, I'm less inclined to believe the sole executive because politicians have a history of not always telling the truth. But when Congress gets together in a bipartisan effort, an overwhelming majority of both Republicans and Democrats say this is a national security threat, I don't see how I can argue the other. So I'm lost on that one. I wanted to reserve a little bit of time for questions if anybody had any questions. I think Joel's going to bring a microphone around.
Using the federal government, is there any appeal been by the legal firms that were just blackmailed in terms of getting information?
I don't know the status of any litigation by those law firms, but many of the big law firms have been hit with, here is a big list of things you absolutely have to do. Here's a list of things you cannot do. And many of them involve, you must give us 30 million or 100 million in value of pro bono legal services, free legal services for organizations that President Trump finds worthwhile. I haven't seen any litigation yet, and I've been looking. Since it's spring break, I'm going to spend the week trying to find some. Yeah, blackmail and extortion come to mind, don't they? I mean, I used to do pro bono legal services, and if you are forced to do them by somebody who holds, a big dagger over you, that's hardly, public service. It's like the kids in high school that are told, you don't graduate unless you have 20 hours of community service. Well, I'm glad they do it, but at the same time, I'm not going to pat them on the back and say, hey, good job. All they were doing was checking the box to make sure they graduate. But it sounds ominous. It's sort of like going to the various universities saying, you're going to lose $8 billion, or you're going to lose $400 million, you're going to lose, $1 billion and $2 billion if you don't do all of this big checklist of things, because that sounds similar, doesn't it? Good question.
I'm not a lawyer, so I have a very interesting or simple question. What is the requirement for Meta to follow free speech, or what is the requirement for Colombia to claim that they are following the free speech?
Other countries, you mean?
No, Colombia is the university.
Oh, Columbia, the university. I'm sorry. Well, Columbia must follow free speech, right?
Why?
Good question. Well, Columbia is a private university, right? So they don't have to. Now, they have told people in the past, most every private school has said, although the First Amendment doesn't allow us, or doesn't apply to us, we can punish our students if we want. We won't, and we won't punish our professors, we won't punish the faculty. We'll pretend we're public. But excellent question, because those private schools don't have to respect the First Amendment with respect to anybody on their campus. They're just like Facebook. They can ban people if they want. Good point. Good question. Yes.
As far as Columbia University goes, all right, so there's a group of professors at Columbia that are anti-Semitic, and they were organized originally by this guy, Said. And so you said originally in your talk that free speech does not extend to anybody that causes harm about what you say, lying. Okay, so like the famous example is Facebook allowing the Myanmar country on Facebook spreading lies against the Rohingyas, and there was major genocide as a result. And out in Colombia, Colombia is allowing lies to be perpetrated on their campus in which, whether it's free speech or not, their speech is causing the Jewish students harm by intimidation, sometimes physical, and allowing them not to go to classes or take tests. So there's no free speech there.
No, and that's an excellent point. That's a hostile education environment. Our civil rights laws preclude people from engaging in a hostile work or a hostile education environment. I saw that here at UCLA, at least on video, where there were people blocking access to some of the halls where classes were held and saying, are you a Zionist? Do you support Israel? Are you Jewish? I thought, you can't do that. That's far beyond the First Amendment's protection of peaceable assembly, which would be show up with your sign for the reserved hour, make your pitch, and then, leave so other people can use the common area too. And you can't ever block somebody going to class or the library. I fault UCLA and all the other UCs, which are, of course, public, and thus the First Amendment does apply, because when the rental truck showed up with all that construction equipment, somebody should have said, hey, what's going on here? Move this stuff out of here. You don't build anything at UCLA unless you have all the permits, and you don't have any permits. They let everybody down. And yeah, now we're going to see the blowback. I'm not sure the response of the current administration is going to protect everyone's rights. I've read a fair number of commentary that says, hey, stop trying to protect me and use my name, say prominent Jewish leaders, because they know, they say how it always ends, they'll be scapegoated eventually. But excellent point. There was no protection at all for the feelings of people where you're not allowed to threaten people. Oh, that too. Oh, it was more, but feelings plus all those other things, sure. But under the hostile education environment, I can't even hurt people's feelings intentionally because that's going to be a violation. It won't get me put in jail, but it'll get us sued, and we don't like that either. Good point.
So I know we could probably continue with a lot of issues that the Supreme Court is dealing with now, but let's join me in thanking Mark again for meeting with us again this year. I'll just remind you